chance to sign in?
We did, yes. It's the best thing, yeah.
Recording in progress.
Thank you. Would you, when Socket solicited too? Yes. No more? Who's up there now?
Michael Prezzero.
That's right.
I think we have everybody in here.
Okay. Well. Ready to go?
We're on.
I don't know why I'm not getting it. So, it's very informal beginning to this hearing procedure. I don't. I didn't have Zoom installed. Should have. No. Is that Mr. Rudy? Yes. That's his towel. Oh.
Should go back then. It's okay. Oh, you go to the Zoom, but on email.
It's right there. So,
Recording in progress.
Okay. Ms. Desitel, Mr. Libby, can you hear me?
Yes.
Okay.
Good afternoon.
Okay. So we'll start the meeting. This pre-hearing conference is set forth in the statute. We handed out forms for you. And we just, Mr. Harmon, if you want to go over the schedule that we set up.
Absolutely. Our proposed schedule starts off with having the parties to this matter produce a list of witnesses they intend to put forth during the hearing on this matter down in Tiverton. We propose a date of March 1st to submit that witness list and a brief explanation of the testimony those witnesses are going to provide. At that point, once those have been submitted March 1st, it clicks into the next section for the hearing procedure, which would be the submission of an agreed statement of facts or disputed statement of facts between the parties. That we would request that the parties get together and produce that document so that the hearing officer has an idea of what it is that everybody agrees to and what people disagree with, just to try to streamline this process. After that, we would have the pre-hearing briefs and exhibits submitted. Our proposed timeline for that would be the applicants submit their brief by April 15th. The objectors would submit a responsive brief by May 15th. And then the applicants would have till May 27th to submit their reply to the objector's responsive brief. After those are submitted and Mr. Krieger has an opportunity to review all those documents and submissions, then a public hearing would be scheduled. Once the public hearing or hearings, depending on the amount of witnesses, the amount of exhibits, the amount of briefs that we have before us, once those public hearings are complete, Mr. Krieger would develop a recommendation to the full council on how the council should act on this application.
Does anyone have any questions or comments as to the proposed schedule?
Yeah, I have a couple of questions. Is there gonna be an
Could you
opportunity?
speak up though, Mr. Wagner?
Sure. Is there gonna be an opportunity for public comment at all, other than the witnesses that are gonna testify?
Would you like me to?
Yeah.
Yes, there will be. We'll hold public comments down in Tiverton on the matter.
Okay, so people that aren't necessarily identified on the witness list will also be given an opportunity to speak.
Yes,
And just a procedural question, has the hearing officer had an opportunity to review the documents that have been submitted to the CRMC?
1,111 pages.
Yeah, okay, I didn't know if that was something you looked at or not.
Yeah, it's about this big, and it's in the backseat of my car, so I can nibble away at it the past couple of months.
Well, that's helpful to us to know what. Yeah, okay.
Yeah, so along those lines, I mean, I realize that this matter has been pending quite some time. And that everyone is, particularly the applicants, are very anxious to move this forward. And I think that the timeline that Attorney Hartman and his office have proposed, I think is very reasonable to get us on track so that this matter doesn't go on for another couple of years. I have no intention of this being another Block Island Marina case, for example. So provided that the attorneys and the applicants are able to meet these timelines, once we get to the May cutoff, I think at that point we'll be able to schedule the first public hearing in Tiverton. So we will be doing those hearings in Tiverton. I think that the executive director has been in contact with the town, Mr. Marcello.
I believe so, but I'm not aware of
Okay.
it personally.
Yeah, I believe he has, and I believe that the town hall is going to be suitable. Do you feel that that's big enough?
Probably. I mean, how many people would go to the Harbor Commission?
If I may, Mr. Krieger, I didn't mean to interrupt Mr. Marcello, but a couple of points. At the outset, we would like to reserve any rights to retain legal counsel at any
Well,
point in
we
time.
can do that
throughout
at
this
any time,
process.
sure.
We did. Secondly, I guess we came here without the specific understanding that these hearings would be held in Tiverton, and we would proceed to have a change of venue for that hearing.
You would,
Given that the jurisdiction for what has
you
been
mean you would
applied for,
request, you're requesting a
we
change of
would
venue?
request a change of venue.
To where and for what reason?
Well, here or at the CRMC headquarters, for the simple reason that the jurisdiction of the application is the state and not the town of Tiverton.
Okay.
And furthermore, we feel as though the well has been poisoned in the town of Tiverton by virtue of our application. After almost 4 years, having been, we went before the Tiverton Harbor Commission on 3 separate occasions. And so we feel as though we will not get a fair hearing in the town of Tiverton.
Well, Mr. Bowen, the hearing is before me, not before a jury of your peers in Tiverton, so I'm not sure that I understand the
Well,
objection.
Only to Mr. Wagner's question of will additional public comment be available or be welcomed or be allowed, we would suggest that the distinction between a registered witness comment at a hearing is a fine line. At what point does a registered witness and someone who shows up at a hearing, where is that distinction made?
To respond to that, I would be happy to put 150 people on my witness list, but I don't think we want that. I think what we want,
Mr. Krieger, we want a fair hearing.
Okay, hold on a second. Just let Mr. Wagner
yeah,
finish.
so I'd be happy to go through that binder and call all those witnesses and put them on my witness list, spend way too much time that none of us want on this. I suggest if we all have limited witnesses and we tell you what they're gonna say ahead of time, then there's an opportunity for public comment. With a limited time, the hearing officer is gonna say 5, 10 minutes, whatever it is. It's gonna be a lot more efficient to get it done.
Yeah, see, I mean, I've read the objections and as counsel just explained, there's, 150 people that want to come and speak about this. I don't think it's helpful to the process to hear 150 people repeat the same thing every 5 minutes. But the hearing, the reason for this pre-hearing conference is to get these things out. And if you feel that you'd like to file a motion regarding the location of any future hearings, you could certainly do that. From my standpoint, I'm more than happy to do it here. I'd prefer to do it here. But I'd have to speak to the executive director and counsel for the CRMC to get their thoughts on that. 'Cause I know
If I
that,
may speak, Bruce Cox, chairman of the Tiverton Harbor.
I'm sorry, Mr. Cox, but I hate to do this. So because we have a number of different parties here, we just need to know who's going to be speaking for the town of Tiverton. So
Yeah, and Mr. Hartman, could we just go around the table virtually as well and explain who's who and who's representing who? I know a few of you, but not everybody.
absolutely, I think that'd be a good idea, but I'll leave that with Mr. Krieger.
okay, that's great. Why don't we start with the applicants? If you just state your names and,
I'm Malcolm Bowen. This is my father, Patrick, and my uncle Sean.
John Bowen, I'm applicant.
Patrick Bond, applicant.
Mr. Wagner,
Dean Wagner, I represent Jean D'Souza, Richard and Kathy Metcalf, Cynthia Aber, and Kathy and Boltful.
so you have 4 clients that you're representing?
1, 2, 3, 4, 5, 6.
Michael Marcello, I'm the town solicitor for the town of Tiverton.
I'm Bruce Cox, I'm chairman of the Tiverton Harbor Commission.
And I'm Mark Hartman, assistant legal counsel.
And I'm Mark Krieger, the chief hearing officer for the CRMC. Mr. Libby, you have something to say?
Yeah, I just want to introduce myself. I'm appearing pro se. And then I also had a couple of comments about the discussion you had before the introductions here.
Okay, after we hear from Ms. Desatel, you want to identify yourself also?
Good afternoon, Marissa Desatel for objectors Liz and Kenneth Mendez. And thank you for that. I appreciate the clarification.
Mr. Libby, go ahead.
Yes, thank you, Mr. Krieger. With respect to, I think, the bulk of potential witnesses, I think Mr. Wagner's correct that there will be a lot of people that want to testify, but I think it's within the discretion of the hearing officer as to what's duplicative, and you can certainly shut that off at any time that you want based on duplicative evidence coming in and statements coming in. So I think that is within the CRMC management procedures as to, when you can shut that down with respect to potential people coming in. With regard to witnesses, you indicated that by March 1st, you wanted a list of witnesses and a short, this is Mr. Hartman, with a short brief statement of what their testimony is expected. I'm assuming that all of this is similar to a joint pretrial memorandum with agreed facts, disputed facts, witnesses, what the evidence is expected to be shown. I guess my only suggestion with respect to witnesses to short circuit or to streamline this somewhat, would the hearing officer consider doing witness testimony direct already submitted to you, and then just cross-examination? I think that will really cut down a lot on the time of this potential hearing.
Thank you, Mr. Libby. We, just for the benefit of myself and everybody else in the room, you are a retired attorney, is that what I'm to understand?
That's correct.
Okay, so you're not a member of the Rhode Island Bar?
I'm not a member of any bar right now. I retired in July of 2020.
Okay, because, you know, out of an abundance of caution and wanting to, you know, be fair and equitable to everyone concerned, you know, we noted your request, but we have some concerns about, you know, what capacity you're appearing as and whether you should be concerned about, you know, the Rhode Island Bar Association and the unauthorized practice of law.
I can assure Mr. Krieger, I am not practicing law. I'm representing myself. I'm not representing anybody else. I believe I have the ability to appear here pro se as an objector, as I'm doing, as the Bowens are appearing pro se.
As we are applicants.
They're applicants. Yeah, they're the applicants.
And you're appearing pro se.
Without counsel at the moment, that is correct.
Well, we just wanted to point that out to you, Mr. Libby, so that you know, you're aware of that concern.
So what exactly is the concern, Mr. Krieger? Krieger, excuse me.
So it's that we are affording you, at least for this particular meeting, we are affording you the status of a, if you will, of an attorney, even though you're saying that you're representing yourself pro se. So
That's correct. I am not appearing here as an attorney. I'm not licensed in any jurisdiction.
but this was not a public hearing in that respect. It was a pre-hearing conference with the attorneys and the applicants to go over the procedure and so forth. So again, we've afforded you this opportunity, but you know, we're just concerned about you know, how that's going to affect matters in the future. I just bring that to your attention so you're aware of it.
Well, I've read the CRMC management procedures, and I don't see anything in there that prevents me from appearing pro se and representing myself as an objector.
Thank
If you could point that out to me, I'd appreciate it.
I have no intention of doing that at the moment.
Okay.
But I've heard what you have to say, and I thank you very much.
Okay. Thank you. I appreciate that.
Mr. Krieger, if you could just consider, one of the things he said is that you can consider the possibility of making this more efficient by allowing testimony through affidavit that the Bowen or their attorney, if they have the time, to then cross-examine. That's just, it's right in the statute as a possibility, as you know, in a lot of these hearings are held that way, as opposed to having direct examination.
Right.
Just, I think that should be up to you.
Well, again, that's what we're trying to do here is streamline the process.
And I think the Bowen should have the opportunity to cross-examine any witness. They
Oh,
want.
absolutely. Whether they appear with or without counsel.
100% agree.
Yeah.
If I may, Mr. Krieger, to get back to the issue of venue, I can tell you that, in my opinion, as chairman of the Harbor Commission, while I'm an attorney, I'm not an attorney in this status at all. It's the issue of venue is usually only changed for purposes of fairness within the jurisdiction. when you have the jury pool that be selected, that sort of thing. We don't have that here.
Well,
We do
that's what I
have-
mentioned to Rollins.
Exactly. So and I don't know as a decision had been made on that because they had raised their question. I wanted to make sure that you're well aware of the fact that the town of Tiverton released the Harbor Commission. And I can probably assure you the town of Tiverton would be extraordinarily upset if the hearings were not held in Tiverton. I can understand your desire not to have to deal with the Providence Bridge. I believe your office is in Lincoln, if I'm not mistaken.
No, I had to close my private practice.
Oh, okay. But the pathways over to Tiverton, going from CRMC would be by way of the Newport Bridge, or from here. The way I'm going to go home is by way of Pawtucket and Newport Avenue. Because the Providence Bridge is obviously a nightmare. So I adamantly encourage you to do as I believe that has been said, that we'd be having not only hearings from public hearing comments in Tiverton, but the actual hearings themselves. And in terms of the physical location, in terms of space and room, my suspicion is either town hall or the main room in the library, I think, is a little larger than the town hall. From a standpoint of public space, I could be corrected on that, but it's meet regularly in either location, and my perception is that the library main conference room is actually a little larger of the town hall. It's certainly got greater breadth, but we can investigate that and cooperate with you.
Well, I wasn't, I wasn't expecting the applicant's concerns about the venue, but this is something that CRMC council and the staff have discussed it. And I guess we're going to continue to discuss it.
Yes, so the standard procedure for these hearings is to hold them in the town that's most affected. So the discussion, as Mr. Krieger said, Tiverton is the location for the public hearing that likely, based on the schedule that we put forth, is going to be held sometime in June. That's not a certain date, but if you would like to submit, as Mr. Krieger said, a motion to change venue, you may do that, and we'll consider it. Mr. Krieger will consider it. And then obviously the town and the objectors will have the opportunity to rebut that. But that, I don't want to speak for Mr. Krieger, but I don't think that should affect the current briefing schedule, which really is the subject of this meeting. And I don't want to get too much in the weeds with, what's going to happen when we get to the public hearing. That's 6 months out. We're far away from that. I don't think that discussion is particularly appropriate right now.
May I just interject for a minute? So first off, when we came tonight, we were unaware that the venue would be Tiverton. We thought that part of the deliberation tonight or this afternoon would be to help determine where it might be held. And as an example, perhaps, of how we're fearful of not getting a fair hearing, subsequent to our unanimous recommendation from the Tiverton Harbor Commission, 3 or 4 of the members were replaced by people who object to our application. And subsequent to that, neighbors, subsequent to that, they have objected routinely.
Well, I'm the hearing.
If I may, Mr. Krieger,
Go ahead.
I think that the idea of a fair hearing, Mr. Krieger's the hearing officer, whether he hears it here or hears it, down there, it really doesn't make a difference. The thing is, Mr. Krieger's the hearing officer, he's going to be one that's making the determinations. The question is whether it makes it accessible to the public and those that are in those the affected towns to be able to participate. And CRMC, as an agency, that they want to have public participation. So I think that it's appropriate to be held in Tiverton. As I said, and as Mr. Krieger indicated, if you would like a change of venue, you may submit a motion that we will decide on a future date.
Yeah, the whole, the whole idea is it's taken a long time to get to this point. I'm sure you would like to get this over and done with as soon as possible, correct?
Correct.
Go ahead.
The reason that it has been brought to this point is by no doing of ours.
It's been delays.
The delays have not.
Continuous.
I was just,
No delays from you guys?
I was just.
Yeah, I mean, that's not true.
Well, I was just appointed as the hearing officer in June, so I'm coming into this with a fresh outlook. I have no preconceived notions. Said, I was handed a stack of 1,111 pages. And a considerable amount of that was the objectives. So, you know, I'm going to be, I've got an open mind. As I said, it's certainly more convenient for me to be up here. I live in Lincoln. But as Attorney Hartman said, if you want to file a motion contesting the location of the hearings, we'll certainly take that into consideration.
Thank you.
And again, we've got, as he also said, we've got plenty of time to consider that. And you've also indicated that you may retain legal counsel, and that may change your thoughts on this also. Yes. Mike.
Thank you. So, again, on behalf of the town, and I'm a little bit of a fish out of water because I was just asked to get here about a week ago. So I know that the town submitted to the town administrator's office an testimony, or at least documentation to the CRMC when it was originally heard. But I do want to get back. I'm not here to argue the merits or anything, but I did think we're here to discuss the scheduling order.
That's it.
And if we could just get back to that, I'd appreciate it. Now, I think if the applicants are going to get counsel, and it's up to them, I respect that. But if they were going to go out tomorrow and get counsel within the next 30 days, then this scheduling order is going to go out the window anyway, because their counsel is going to want more time, which being on that side of a couple of times in my life, I understand that you need to prepare. So in fairness, again, my suggestion would be if they are serious about getting counsel, I know it's an expensive proposition for them, that we know that within the next 30 days or within 15 days or some point, so that we can then we can react. Because I think this schedule will be, have to be modified based upon that. Certainly as an attorney, and no offense to the applicants, I prefer to be dealing with an attorney on the other side, just because we get the procedures a little easier and we know it, we talk the same talk, but I understand that that's an expensive proposition. So, but I would like to at least have a time frame as to a limit as to when they can get an attorney. And then once that is done, once the decision is made one way or the other, then we can get back to the scheduling. But, as it sits right now, the scheduling is fine with me. But I would be more concerned that if within 2 weeks they said we hired an attorney and then this goes out the.
Well, let me ask you this. What time frame do you gentlemen think you need to decide whether you're going to seek counsel?
I just wanted to retain that, right, Mr. Krieger?
Well, of course you have that right. You can do that at any point.
At this particular point in time, we're not intending to do so.
Okay.
The green statement of facts, that might be a little bit ambitious without attorneys on the side.
I understand.
But we're gonna obviously do our best to get it done.
Ms. Desatel, do you have anything to add to this?
Yeah, thank you. I just raised my hand virtually here. I was going to ask to tag on to what Attorney Wagner just said. Are we, or is the CRMC and Mr. Hearing Officer inclined to accept stipulations of facts between the objectors? Or are you only interested in narrowing down the stipulated facts between the opposing parties?
I'd say both.
Okay.
If we can get the objectors all on one page, that's going to cut down on repetitive testimony. We don't need, no matter how much we limit it, we can't refuse to listen to people, but we can set time limits. And I don't think it does anybody any good in this process to hear a parade of the same testimony.
And then secondly, thank you, I appreciate that. Secondly, are you anticipating the parties providing opening and or closing statements or a post-hearing memo?
Post-hearing memo may be appropriate. We haven't maybe got that far in terms of opening or closing. I have no objection to you taking advantage of that.
Okay,
If I may, Mr. Krieger, I think the typical subcommittee procedure, and if Mr. Krieger would like to follow this, that's up to his discretion, would be to have the applicants put their presentation on, have the objectors one at a time put their objections on the record through an opening statement and then through witness testimony. And then the applicants would have an opportunity to respond to what the objectors have put forth.
okay. Thank you.
But again, that's up to the discretion of the hearing officer.
Can we anticipate a pre-hearing order subsequent to this meeting?
We hadn't discussed that. You mean a pre-hearing order to agree to the time frame or to?
Yeah, and in my experience with administrative hearings, there's some written formal order that captures all of the dates and deadlines and requirements by the hearing officer.
Yeah, can we get us some stipulations on that?
So could we have, I mean, and again, I don't want to interrupt, but if the parties would agree, would they submit a stipulated order, basically saying that this is what both sides propose as the time frame for a submission of each element that the hearing officer has laid out here, and submit that for an order of the hearing officer. So if one of the parties could draw it up, an order for the hearing officer, the other party agrees and the hearing officer signs off. Would that be acceptable to both sides?
Gentlemen?
Given that what we have before us here is just a proposed procedure, would you entertain the idea of altering this procedure?
And absolutely, in what way?
Well, if we're intending to get this done, agreed statements of facts or disputed facts
Already been laid out.
have been laid out in those 1,100 pages. And I don't think that we're going to do anything. Clearly, there's a lot more disputed facts than agreed upon facts.
And to a large extent, those disputes have been addressed by CRMC staff and the staff reports. All of it has.
I think it's very clear that the statute calls for simplification issues.
Yeah,
That's
I
what we're trying to
mean,
do.
I'm not, you know.
Could you repeat that, Mr. Wagner?
The statute's very clear. It calls for a simplification of the issues. That's what we are trying to do to take that 1,100 pages and make it something that we think these are the relevant facts. You guys agree with half of them, but these are the facts you don't agree with. So that's where he's going to focus.
Really, the staff report did boil that down.
Excuse me,
We're not here to do, you know, I'm not here to do your job. And I'm not here to do his job. And that's why we have this meeting, and that's why we're trying to get a concise plan going forward. So, you know, I understand you want to maintain your rights to hire legal counsel. You know, but it's not up to me to digest the 1,100 pages into a stipulated set of facts and facts that are in dispute. So.
If I can have this, Mr. Wagner's right. The statute calls for a simplification of the issues, and as part of that simplification, an agreed statement of facts or disputed facts is part of that simplification process. And that's what we're trying to do here with this hearing officer procedure, is we're simplifying issues and driving at, well, what's at the heart of this matter, so we can get right down to it, and we don't have thousands of pages that have to be reviewed for how relevant they are to the matter.
I'm not trying to create more work. We're trying to create less work for all the parties involved. And, you know, that benefits you, it benefits their clients. You know, these gentlemen are, and ladies are hired generally on an hourly basis, so, you know, the less work that they have to submit, the better it is for their clients. And same on your side. So whatever you're able to do up to the, you know, prior to hiring an attorney, is to your benefit.
Can I ask, for the applicants, who would be our contact person to be dealing with? Because we have 3 people, so it would be you.
I've been in contact with Mr. Hartman. And if I may, just inquire as to how Mr. Libby were to get the Zoom information prior to this hearing, because I was not afforded the same courtesy. Is Mr. Libby still on this call?
Yes,
Yes, he is.
I provided Mr. Libby's contact information to Mr. Hartman.
Yes, and I provided the Zoom information to Mr. Libby. And I actually, just before this meeting, provided it to you with the understanding that you were appearing in person tonight. If you had called me again, I would have been happy to provide you the Zoom link earlier.
Only that we spoke yesterday and had requested it, so if I may.
We didn't have it, we didn't get it till this, we didn't get it clear till this morning.
These are, what we're doing at this meeting tonight, you're here and the objectors are here. We're trying to hash out a procedure for going forward. That's all we're doing here tonight. We're not trying to nitpick on certain issues.
It's not an evidentiary here. We're not here to discuss the merits of the case, just how we're going to get the case presented so that we can get a resolution.
Mr. Krager, if I could interrupt, since I'm not billing myself by the hour, I'd be happy to take the laboring oar and put together a proposed order and send it around to everybody.
Objection.
You'll have so it's a stipulated order, so you'll have the opportunity to review and make comments. And you have to create an order that everybody agrees to. If everybody doesn't agree, then you have to come back to us. You'll talk to me, you talk to Mr. Krieger, and we'll say this order is unacceptable. The parties have not agreed. The parties' agreement is not acceptable. So it's not going to enter just by the mere fact that Mr. Libby drafts it. You will have the opportunity to review. And if it's unacceptable to you, you just inform me or Mr. Krieger.
Mr. Libby doesn't have any more standing than anybody else who wrote a letter in objection or in favor.
Mr. Libby has entered an appearance as a pro se litigant.
But he's not a litigant.
He entered an appearance pro se.
He's also submitted substantive objection, multiple pages.
He's an objector.
Excuse me. The purpose of this hearing, and I apologize, Mr. Krieger, is to set out a procedure. Now, I want parties to, and again, I'm sorry, Mr. Krieger, to agree to a procedure that we can move forward on. That's all that we're here for tonight. And we can hash out the substantive issues when we get to the public hearing.
That's why I would suggest that let's have a discussion on these dates. So the March 1st, March 15th, the briefing schedule, are they okay? I will tell you that end of March might be difficult for me because I plan on going on vacation, but other than that, I can meet at least the first couple of dates on this list.
Mr. Hearing Officer, the March 15th date, I think is too ambitious. However, we'll be happy to send to the app. I mean, they have the burden of proof, as you know. We'll be happy to send them what we think are agreed statements of fact, and they can deny them and submit their own. But I'm just concerned about the March 15th date, just to let you know. But we can live with it.
Mr. Bowen, would the March 15th date for an agreed statement of facts be acceptable to the applicants?
So an agreed statement of facts, I don't know how we would come to that consensus.
So what would
We can
happen?
present facts.
Yes, absolutely. So generally, in many different administrative proceedings and in litigation generally, one party will submit a statement of facts and you'll have the opportunity to deny or agree with them. If you agree with them, that's a fact that's going to be in the record. If you deny them, then that fact doesn't exist as far as
It becomes a
disputed
disputed fact. It becomes a fact and an issue in dispute. Doesn't become a fact until it's agreed upon or the evidence produces.
And what makes it difficult here is the plaintiffs have the burden of proof. And as you know, the federal court, state court, keys usually come from the plaintiffs first. They initiate here, but we can make an exception and try to make an exception. That's the only reason why I think it's
Mr. Magnusky, can you just elaborate on that burden of proof that Mr. Wagner is referring to?
Yeah, you're the applicant, you have the burden of proof
To prove
to,
that we have received all the necessary approvals that every other applicant for the last 25 years has received?
Well, Mr. Krieger, if I
Yeah, go
may,
ahead.
so the burden of proof would be to demonstrate that you meet the goals and standards of the CRMP and that you comply with the category, you've complied with the category B standards. So, but I'm not advising you. This is a determination that you have, if you choose to go with legal counsel, that you have to talk with them about what standards exactly you need to meet your burden.
And you would suggest that staff report does not meet that?
The staff report is our internal review of the matter. And you can rely on the staff report if you so choose as part of your evidence, but the objectors will have the opportunity to try to undermine the staff report. But to us, the staff report is something that we rely on heavily as we review these matters.
It's the jurisdictional authority, like the staff report would
Well,
typically be.
No,
no,
the authority belongs with Mr. Krieger. He's the decision maker, not the staff report.
but I can give whatever weight to any of the evidence that I deem appropriate. I can, if we have 150 people that object and it's all the same objection, I mean, I have the ability to dismiss that or accept it. I'm the trier of fact. And the staff report is one piece of evidence that's been submitted. And you have the opportunity to submit whatever evidence, additional evidence you feel is relevant to assist me in making my decision.
Thank you.
So, I'm sorry, so based on Mr. Wagner's comments, I'm wondering if we could push the agreed statement into effect to the end of March.
Okay. Well, Mr. Bowen and Mr. Bowen, what are your thoughts on having these matters, the first date be the end of March 31st?
March 31st,
Instead of March 15th?
instead of March 1st.
Instead of March 1st?
No, I'm sorry, it's the agreed statement of facts.
Okay, the agreed statement of facts, instead of March 15th, March 31st.
Correct.
Yeah,
That would be agreeable, Mr. Krieger.
okay.
Mr. Krieger, if I may, the March 1st date for submission of witness testimony be acceptable to, now this is a short, brief statement of what the witnesses would say. Would that be acceptable to all parties?
Yes.
Yes. Yes.
Ms. Desatel?
Yes, subject to what the applicant responds with, unless you're contemplating that all parties will be submitting the witness list and summary together.
That's what we anticipated. Yeah, we had anticipated that those would be simultaneous.
Okay, then yes, that's great. Thank you.
Right, what kind of flexibility is gonna be given for amendment? For example, to the witness list, if we get a list from the applicants, all of a sudden there's a couple of people on there that are, for example, experts or whatever, we might want an opportunity to
Absolutely.
An opportunity to what?
amend our.
Amend their list.
Oh, I see.
And you would have the same right. So I'm assuming that you both intend to present testimony and be witnesses on your own behalf.
Both ways.
Okay.
If I may inquire, with regard to Mr. Cox and his position as chair of the Tiverton Harbor Commission,
Mhm.
would his presence today here preclude him from being?
No,
So again, I'm here on behalf of the town. Mr. Cox is an agency of the town. He happens to be here because he's somewhat interested in it on a personal level as chair of the
Yep.
commission, but Mr. Cox will probably most likely appear on my list as a witness to give testimony in this matter.
So he would then be cross-examined at a hearing.
He'd be subject to cross-examination, correct? Well, so that's up to you to decide, but yes, that's generally the procedure, yes.
Yeah, you're gonna have the right to, you or should you choose to engage an attorney to cross-examine any of the witnesses, including all of the objectives. But again, the purpose of this is to, make that list a little bit smaller. Mr. Libby, do you have anything else?
No, my office still stands to put out a proposed order to everybody.
If that doesn't appear to be acceptable to the applicants, is there anybody that's willing to put that proposed order together other than Mr. Libby?
I'll be happy.
Mr. Wagner?
Yeah, you can do it.
Thank you.
Is that acceptable to the applicants?
Mr. Libby, thank you. And again, you have the opportunity to respond to.
Patrick, do I have your email, Patrick? Are you?
You may. BOWEN underscore COX .net. So Bowen underscore, I beg your pardon. Bowen underscore CO at Cox.net.
Mr. Hearing, I'm sorry, so if you push the B out by 15 days, my proposal would be to submit to advance everything under C by an additional 15 days. It'll be April 30th, May 30th,
Mr. Bowen, you say any objection to that?
15 days.
At this point in time, that seems to be agreeable.
Okay.
And that'll be April 30th,
Yes.
May 30,
Yep.
and,
Make it May 31 if you want, it's the end of the month. To you.
and
June 12th. June 12th. Or June 11th. It's 31 days. Yeah, June 11th.
Just so I'm clear, the protocol that we're considering right now is new to me. If a party is submitting the proposed order, it still will be signed by the hearing officer, correct?
Yes.
Okay, thank you.
So, just to get back to the venue, you understand what I requested earlier? If you are intent on having the hearing somewhere else, so you'll submit a motion to that effect.
Okay.
Okay. And I take it, Mr. Wagner, Mr. Marcel, Mr. Cox, you all prefer to have it in Tiverton.
Yes,
That is correct.
Ms. Desatel?
if they want to have the aquaculture farm in Tiverton, we want to have the application.
Ms. Desatel, your thoughts on that?
No preference. I would just request that the applicant respectfully copy everyone, including the objectors, on anything filed with Mr. Hearing Officer.
When you say the objectors, are you talking about all 150 of them that have submitted?
The formal objectors that are parties to this pre-hearing conference.
Okay, so you're just referring to the represented objectors.
Yes, please.
Okay, thank you. Mr. Libby, anything on that?
I've got no problem with that.
Okay. Okay. Does anybody else have anything they want to bring up, discuss, dispute?
Mr. Hearing Officer, Mr. Libby, I'm assuming that if the applicants file a motion for change of venue, that the objectors will have an opportunity to respond.
Absolutely. Absolutely. Do you want to set a, so we don't throw all this, so we want to set a date by which they would need to have this motion? That's
Yeah.
appropriate.
I think it's appropriate as long as it gives the objector sufficient time to respond to it.
Yeah. Well, actually, I mean, with this schedule here, any hearing isn't gonna occur till June, so they've got plenty of time to make that decision.
So should we set a date? So I want to give, I think we should give the applicants an opportunity to create that motion, but the objectors also have a right to be able to respond to that. So you give the objectors an appropriate amount of time to be able to respond. If I may, Mr. Hearing Officer, I'll ask objectors, would you find that there'd be an adequate amount of time for you to respond? Would 30 days be sufficient? So if we set it 30 days prior, if their deadline is due 30 days prior to, let's say, June 1st, that would be acceptable? Yeah.
30 days prior to the hearing?
Well, we don't have a date set on the hearing, but that's just generally when we get closer to that date, you'd have time to respond, and then give time for Mr. Krieger to review and make a determination after he's reviewed. So your motion would be due, I guess, in May 1st. May 1st. Objectors have till June 1st to respond. So is that acceptable to everyone?
Yes, Mr. Libby.
Mr. Bowen?
Yes, that's acceptable.
Yeah. So, sorry.
Ms. Desatel, would that be acceptable to you as well?
Sorry, guys, we're in a weird situation here. I'm looking at Rule 12 to look at when a motion for change of venue can be filed, but we're not actually talking about a change of venue. This is almost like a request for Mr. Hearing Officer to recuse. So I don't know, the civil rules of procedure don't apply. 30 days to have time enough to respond to any kind of motion, I think would be okay. I'm getting caught up in this discussion about change of venue.
Well, I'd say it's certainly not a motion for the hearing officer to recuse. I think it's just, I think it's up to the applicants to, they can make that request. I'm not necessarily saying it's a motion, it's a request.
Yep.
The hearing officer, and I just want to make sure that the objectors have adequate time to respond to that.
Understood. Sure. 30 days should be fine.
Mr. Hearing Officer, Mr. Libby, can I suggest that if there's any pre-hearing motions, that they also be filed by May 1st with a response by June 1st so that everything can be done in a more streamlined fashion?
That sounds reasonable. Any objections to that?
I'm sorry, what were those dates again?
May 1st for any pre-hearing motions.
And then objections
or
due
requests. Objections due by June 1st.
June 1st. Got it. That works. Thank you.
Sorry, what's the date of the pre-hearing motions?
May 1st.
Thank you.
Mr. Bowen, do you have any further questions, comments?
With respect to pre-hearing briefs and exhibits, that would include any documentation as far as deadlines go, right? As far as submission of deadlines?
Yes. And you may want to get a copy of the state statute as it relates to the procedures here and that we're following. Okay.
Mr. Krieger, if I could, the only thing I anticipate we may run into problems with respect to any evidence, documentary evidence or things like that are going to be submitted. how do you want to handle that with respect to having agreed upon evidence that we can put in and disputed evidence that we can argue with, I guess, at the hearing, or not, depending on how you want to proceed with that kind of issue.
Items that would be considered exhibits.
Yes. In other words, generally the parties will exchange exhibits before any hearing. And if there's any objections to certain ones, those are set aside. The ones that are agreed as stipulated, they just go in as you know, undisputed facts kind of thing. Again, I'm just trying to streamline so that we know going in if there's objections to certain things, how do you want to handle that? Do you want to handle that at the hearing, which may not work very well with the public there, or as a pretrial
No, we do
conference?
pre-trial matter. There's a pre-hearing matter. It's not a
Okay.
trial hearing. Yes, that's how we'd have to do it.
Do you want to pick some dates as to when that exchange would happen and objections filed, stipulations, et cetera?
Well, it's right here in part C. You don't have this in front of you, but pre-hearing briefs and exhibits. So that's covered under this handout that we have that we can send to you.
Yes, I'm sorry, Mr. Libby and Ms. Desatel, we do have a handout in front of us that has the relevant dates. But once we have the order prepared, it'll be distributed to everybody if you hadn't seen it, and so you'll be very aware of what dates are.
Are we gonna move that date and the footnote for the exhibits 15 days as well? I didn't see that. The footnote number 2 called for the exhibits to be submitted by May 27. Should that be moved 15 days as well?
To June 12th. Yeah, that's what we
It said June 11th.
Yeah, that's what, June 11th. That's what we had put.
Okay, right, you said June 11th for CC,
Right.
but we went down to the footnote, that's all. Just clarifying.
So I think that the idea, and if I may suggest, Mr. Green, that the date of the exhibits align with the reply brief of the
Yes,
applicants.
that's it. June 11th or June 12th, what are we going?
Yeah, I thought we were
I
going
think
to
it's
June 12th.
well, 30 days, I think, because there's 31 days in May. I think 12, 15 days is June 11th, I believe.
Okay.
I have a calendar in front of me.
June 12th. Give us the extra day.
Yeah, that's fine. June 12th. Okay.
Mr. Bowen, is that acceptable?
So
The 12th
the
of June,
June 12th rather than the 11th.
the final day to submit exhibits.
And the reply brief from the applicants?
Yes, it would be the same day.
Okay, thank you.
Well, if there's nothing else, thank you all for participating. Again, the goal of this meeting and my goal as a hearing officer is to move this forward a little bit more expeditiously than has occurred in the past. And in order to do that, we'll need everybody's cooperation to try to stick to this schedule as if at all possible. I mean, Mr. Wagner, you raised the question of, further amendment. That's always, we'll take it on a case-by-case basis.
I can even put something in the order to that effect.
It's fine.
Now, in terms of submitting, is it going to you, or do we have your email, or should it go through the CRMC?
Both. Might be best if it goes through. So.
Yeah, one,
I mean, the public should understand that, you can't have ex-party conversations with the hearing officer. So anytime I communicate, I want to make sure I copy you on it, so we're all know what's happening.
There's a C-staff, and it just goes to a general mailbox, I think, maybe that would be.
yeah, we'll check with CRMC staff, we'll probably have you send it to the administrative office.
Yeah, I'll distribute an email with the.
Okay.
Make it forwarded to Attorney Hartman and myself.
Maybe a docket list might be good for this proceeding. Mr. Hartman?
Ms. Stacy, I agree with you, and I'll work with the office manager to see if we can create something along that line, along those
Okay.
lines.
All right. Thank you again. Nice to meet you. Nice to meet
Thank you.
Nice to meet you all.
Thank you, Mr. Krieger.
Thank you very much.
We'll be in touch. Thank you.